Pleasure to be with you all today. I'm going to be speaking about three things related to Ontario's Not-for-Profit Corporations Act. Firstly, what's new in it? And we're going to focus on three main things that are new. Secondly, what steps nonprofits may need to take to bring your governing documents into compliance with the new act. And finally, looking at what free resources CLEO can offer you, that's Community Legal Education Ontario, to help you with that transition. So you heard that I'm a staff lawyer at CLEO, Community Legal Education Ontario. We are a legal aid clinic, part of Ontario's legal aid system. In contrast to other legal aid clinics, we do not provide one-on-one legal advice or representation. We provide general legal education and information like this that I hope you'll find is plain language, practical, and of course, accurate. Now, my corner of CLEO is a small corner. We have resources in all kinds of areas of law, social security, housing, immigration, employment, discrimination, you name it. The reason I mention this is you, your staff, your volunteers, or the communities you serve may have legal issues and they may come to you with questions. You may wonder, where can I direct them? Well, one place you can direct them is our website, stepstojustice.ca. Additionally, if you have frontline workers who are getting these legal questions and don't know what to do with them, we actually offer training to frontline workers to increase their ability to connect their clients with the legal information they need. You will be provided with a copy of this PowerPoint after this session, and you will find a link to a request form at the bottom of this slide. I would be remiss if I did not mention that these sessions are done in partnership with the Ontario Nonprofit Network and are possible thanks to the generous support of the Law Foundation of Ontario. So with that, a few disclaimers. Firstly, this presentation is general legal information. It's not tailored legal advice. I can't tell you what's best for your particular organization without knowing far more about your values, your mission, your reading your governing documents in full, knowing your corporate history, and so on. So when I say something is general legal information, I really mean it. It's not wink, wink, nudge, nudge. This is actually legal advice. Secondly, today is a high-level overview of the ONCA. The goal is to get you oriented to understand the process and some of the big ticket items. It's not intended to be comprehensive. To learn more about the ONCA, I encourage you to check out our website, nonprofitlaw.cleo.on.ca. I'll also be coming your way in December to deliver a deep dive working session. So you can ask Tamara for more details on that session and how to register. Additionally, the session is just about the ONCA. There may be other areas of law that affect your governance. For example, if you're in a regulated sector like childcare or healthcare, or if you're a charity, there are other areas of law to think about. I'm happy to take questions on those topics, but by default, I'm just talking about the ONCA. Thirdly, today is about law. It's not about best practices. Just because something is legal doesn't make it a good idea. My job is to highlight for you the options that are available to you. Your job is to figure out which of these options actually make sense for us. And then finally, today is about law. It's not about your funders' expectations, particularly when we come to talk about the financial review requirements under ONCA. You'll see there are lots of new flexibilities under ONCA besides just getting an audit each and every year. And you may want to take advantage of these flexibilities. It may save you money and time, but your funder, if you have one, may still require an audit in each and every case. So that's a conversation for you to have with your funders. And I know that many funders are reviewing their expectations for financial review in light of the changes in the ONCA. So with all that, I want to begin with a land acknowledgement and also to highlight a very fundamental lesson that if you take nothing else away, I hope you take the following away for today's session. So I'm coming to you from downtown Toronto, the traditional territories of the Haudenosaunee, the Wendat, the Mississaugas of the Credit, and other Anishinaabe nations, including the Chippewa. I acknowledge that this land remains home to many diverse First Nations, Inuit, and Métis. I'm also quite cognizant of the fact that as a lawyer, I have a privileged role in systems of colonization that continue to perpetuate harms against these nations. And in particular, as a nonprofit corporate lawyer, I'm very mindful of the fact that when we talk about governance, we're talking about systems that empower some and in the end also disempower others, right? So we should be very intentional about making sure that our governance reflect our true values. And if we're on a path of reconciliation, if we're committed to the ideals of reconciliation, we should ask ourselves, how does that show up in our governance? Now, where I am, there are two sets of treaties that apply. On the one hand, there's the dish with one spoon treaty, pictured on the left in the form of a belt. Dish with one spoon treaty is actually a series of treaties dating back centuries between the Anishinaabe and Haudenosaunee nations. Basically, a resource sharing agreement, according to some, a citizenship law around the Great Lakes region. Contrast that with Treaty 13, pictured on your right, in paper form. Now, in the case of a wampum belt, which the dish with one spoon is, as well as other treaties, the way it works in practice is it's brought to important meetings with a messenger. The belt speaks, so to speak, through the messenger, reiterating the terms of the relationship, which grow and develop as the parties, stay in relation with each other over literally centuries. Okay. Contrast that with Treaty 13, also known as the Toronto Purchase, the first attempt at which was made in 1787. Now, by 1805, the then Lieutenant Governor of Upper Canada was so disturbed by its questionable legality that he had his staff go look for a copy of it. Note, he didn't know where a copy was. His staff found a copy, as I've read the story, literally in a shed somewhere, pulled it out. It was a blank deed with signatures from other pages attached to it. Didn't meet any standard of legality, and they proceeded to negotiate a follow-up agreement, which had its own issues. Why do I tell you this story about these two treaties? Because very often when I meet nonprofits, they relate to their governing documents much more like Treaty 13 than like the dish with one spoon. Meaning to say, they write it down on a piece of paper because some lawyer told them they had to. They file it away, not to look at it again until maybe decades later, because somebody gets nervous. They pull it out only to find that what they're doing in practice has nothing to do with what they've written on paper. Okay. Contrast that with the ideal of the wampum belt, which is iterative. It grows as the relationship grows. It's fundamentally about the underlying relationships, and it's brought out on an ongoing basis at important meetings. Okay. If you take nothing else away from today's session, I hope you take the following away. Compliance with ONCA, as compliance with any law, compliance with the treaties, is not just about what we write down on paper. It's how we take the ideals that we've set down on paper, the rules that we've set down to reflect those ideals, and we actually integrate those into our ongoing practice. So today we're focused on updating our governing documents, which is an important first step, but it's just that, it's a first step. Governance is an ongoing process in the life of any nonprofit.
Paper too, right? Not everybody.
I would just ask that everyone make sure you're on mute. And Tamara, if you can mute, certainly. Thank you. Okay, so with that in mind, we will focus on some key terms to make sure we're all on the same page. So, ONCA, Ontario's Not-for-Profit Corporations Act. It took effect on October 19th, 2021, and it replaced Ontario's Corporations Act. It applies to provincially incorporated nonprofits. So if you're incorporated under the Canada Not-for-Profit Corporations Act, it doesn't apply to you. You can save yourself the next 2 hours. You don't need to be at this session. If you are an unincorporated group, meaning you're, let's say you're a program of a larger organization, maybe a program of a municipality or something, you don't have your own separate legal existence. You don't need to worry about ONCA. ONCA doesn't apply to you. Let's say you're a business corporation that happens to run on a nonprofit basis. ONCA does not apply to you, okay? You may be a charity, and then ONCA would apply to you if you are incorporated provincially. Okay, charity status is different from where you are incorporated. ONCA cares about, are you incorporated provincially or not? If the answer is yes, ONCA, broadly speaking, applies to you. If you're a condo corporation, ONCA does not apply to you. Nice to see you, Vince. All right. ONCA is a general piece of corporate legislation, which means that it applies to things like when and where do you have to have a members meeting? How do you take votes? How do you have elections? All that good stuff generally falls under ONCA. So that's what we're talking about here today. Governing documents. This is a term I've already used. What do I mean by it? So generally speaking, from ONCA's perspective, there are three kinds of governing documents. There's your letters patent, your bylaws, and your policies. So first, let's talk about letters patent. Letters patent is the document that the government, generally speaking, would have first sent you when you became incorporated. It would have things like the name of your organization, so its official legal name, your purposes, any special provisions you may have, your founding directors, your address, and so on. Under ONCA, letters patents are now referred to as articles. This change in terminology does not require you to do anything. It's just a change in terminology. So when I use the term articles today, and if you notice the term articles online, know that it likely refers to your letters patent. Secondly, bylaws. You may have another name for this document. You may call it your constitution or your community covenant or your rules of governance. There are many names that an organization can have. The key question is it the document that contains your rules of governance? Things like what's the size of the board? Who's a member? How do you have votes? If it contains those rules, and to approve it, you go to the board and you go to the members, chances are it will be considered your bylaws from ONCA's point of view. Okay, a rose by any other name would smell as sweet. It's not about what you call it, it's about what's contained in the document and how you approve it. And then thirdly, your policies. Nonprofits have all kinds of policies. You have HR policies, confidentiality policies, fundraising policies, gift receiving policies, and so on and so forth. That's great. You're welcome to have all these different policies. For the most part, ONCA does not care about your policies. So when I talk about governing documents, I am talking about your articles and your bylaws, unless I say otherwise. Now, somebody's asked in the chat, you are an incorporated charity, does ONCA apply to us? The answer is, if you're incorporated provincially, yes, chances are ONCA applies to you. If you're incorporated federally, ONCA would not apply to you. So you need to figure out, where are you incorporated? The way you figure out where you're incorporated is by looking at your letters patent, see which government stamped it. You can also look on the Ontario Business Registry, something we'll do later on in this session, and you can actually search yourself. And you can figure, if you appear on that registry as a corporation in Ontario, that means you're incorporated provincially. If you don't appear, it may mean you've got the wrong name, you're not entering the right name, or there's some kind of typo, or it may mean that you are incorporated elsewhere. So you can check the federal registry as well. Okay, key people. There are many people, obviously, that make a nonprofit what it is, but from ONCA's perspective, there are really three key roles. And there are two things that I want to emphasize about these three key roles. The first thing I want to emphasize is that under ONCA, nonprofits are required to have all of these three roles. And secondly, you can have the same people fill more than one of these roles. Even so, there are different rules that apply to each of these roles. So when those same people fill this role, they have one set of rules, and another role, a different set of rules. Okay, so what are these three key roles? Number one, your members. Number two, your directors. Number three, your officers. You're required to have all three. They could be the same people. They don't have to be the same people. If they're the same people, you need to make sure that you're treating each of these three roles differently. They have different rules. Okay, so who fits into these roles? What's the difference between them? So firstly, your members. Members are to a nonprofit as shareholders are to a for-profit, meaning to say that your nonprofit ultimately answers to its members. Even though you may not see them more than once a year, They have important powers like electing the board or removing the board. They have the power to do that. They have the power to approve changes to bylaws. Their approval is required for changes to bylaws, as well as other important decisions like changes to your name, your purposes, any mergers and acquisitions, any major sales of assets, okay? Your members are super important. What if you have no clue who your members are, or you believe you don't have any members? Well, the way to figure out who your members are is firstly to look in your governing documents. Look in your bylaws, look in your articles. Does it define membership there? If it does, the answer to the question, who are your members, is simply the answer to the question, who meets the criteria in your bylaws? If your bylaws say anyone who lives in the area is a member, that's who's a member. If it says anyone who's paid a fee is a member, anyone who's paid a fee is a member, right? It's entirely up to you how you define membership. But once you've defined membership, that's how you determine who a member is. But what if there is no definition or qualifications of membership in your bylaws? Well, then you start to look through past versions of the bylaws. If you can't find any definition there, you can look through board meetings or members meetings to see if anyone's been appointed as a member. If the answer is no one's been appointed as a member, then ONCA says if you have no other definition, then the founding directors on your letters patent, those are members, and anyone appointed as a member by that board, okay? That definition of membership only applies if you have no other definition of membership. Now, if you're in that situation, and most organizations aren't, most organizations have some kind of definition of membership, then the thing to do is to go back to the people listed on your letters patent, and those are the people whose approval you will need in order to update your bylaws and your articles. If those people are dead or missing, or you can't get in touch with them for whatever reason, at that point, you may need to go to court to restart your membership, okay? And at that point, I would suggest maybe seeking legal advice. So that's membership. What about directors? So directors are sometimes referred to as the board or the board of directors, and sometimes unhelpfully referred to as the members of the board. Why do I say that's unhelpful? It's unhelpful because when we get into the habit of saying members of the board, we sometimes shorten it to just members. And then, while the members of the board may be the same people as the members of the organization, they're not necessarily the same people. And even if they are the same people, there are different rules that apply in their capacity as members and in their capacity as directors. Okay, so to avoid this confusion falling into this kind of ambiguity of what does members mean, I'm not going to use the term members of the board. I'm going to stick to the term directors, board, or board of directors. The board is elected by the members, or you can have what are called ex officio directors, people who are automatically directors by virtue of some office they hold. Okay. Your board is collectively responsible to oversee the work of your organization, to supervise it, to make sure the mission of your organization is accomplished. The buck stops with the board. The powers of directors are collective in nature, meaning to say that an individual director, just because they're a director, does not have the ability to go into the workplace and start telling people what to do. That would be what's referred to as overstepping your bounds. The power of a director is to attend board meetings and pass binding board resolutions together that then bind the nonprofit. Okay, so directors are, for the most part, elected. They have collective powers. Their duty is to oversee the organization in a general way. Contrast that with officers. Very often I meet organizations that use the term directors and officers interchangeably. And while these can be the same people, they do not mean the same thing. They are different roles with different rules. We use titles like president, secretary, treasurer, and so on to refer to officers, and all those are fine. You could come up with whatever titles you want, but generally speaking, an officer is somebody who's been appointed some kind of executive authority, okay? By default under ONCA, officers are appointed by the board. When I use the expression by default or by default under ONCA, I mean this is the rule unless your governing documents say otherwise. So unless your governing documents say otherwise, officers are appointed by the board, Okay, that's different from the board, which is elected by the members. Officers have individual jobs to do. I mentioned that, president, secretary, treasurer, and the powers they have are the powers they need to accomplish their specific job. So that's also different from the directors. The directors have collective powers, officers have individual powers and individual jobs. Okay, so with that in mind, I see there's a question in the chat, so I'll address that question. We are a not-for-profit group in a municipality, but are not funded by them. We have our own bylaws and governing articles, hold elections once a year, just went through an election. Okay, thank you for sharing that. If you have an independent legal existence, that it means you're incorporated, and articles would indicate that an organization is incorporated, then if it's provincially incorporated, ONCA may apply to that. The funding relationship with the municipality doesn't matter. ONCA applies based on where you are incorporated. Okay. So you're here, so probably on some level you care about the ONCA. Here are 4 reasons why you might want to care or get motivated if you're not, and 2 reasons why nobody needs to lose sleep over the ONCA, even though there is a deadline coming up. So what are 4 reasons to care? Well, number 1, it's an opportunity to revisit your governance, especially if your organization is in a similar position to what I mentioned earlier, where you haven't looked at your governing documents in years. This is really an opportunity to pull them out, maybe literally blow off the dust, and ask yourself, do these rules still make sense for us? Is our governance framework hindering our ability to do our work, or is it helping us be effective decision makers, accountable decision makers, responsive to our communities, and so on? ONCA presents some new opportunities for how we do our governance. There's new flexibility on the board, new flexibility in how we do financial review and so on, that may result in time saving for you, money saving, and other advantages to your organization. So you may want to take advantage of some of these things. That's a second reason to care about the ONCA. Thirdly, less inspiring, your funders may ask. For them, it may be a signal that your organization has its house in order, that's on top of its obligations, that it's completed its administrative work, and so on. And I've certainly spoken to funders who have expressed this to me, that they're asking their fundees, have you updated your governing documents to comply with ONCA? And then finally, to avoid confusion later on. So this is where the timeline comes in. So ONCA took effect on October 19th, 2021. And nonprofits have a 3-year transition period ending on October 19th, 2024. Okay, so we just had the 2nd anniversary recently. So there's just under a year left in this transition period, in which nonprofits can update their governing documents to be compliant with the ONCA. What happens at the end of this 3-year transition period? Well, nobody needs to worry that your organization is going to poof out of existence. No one needs to worry that there are going to be fines, that you're going to be dragged off to jail. None of that is going to happen. What's going to happen is, from a legal point of view, your governing documents will be, for the most part, considered to automatically transition over to be ONCA compliant. What that means practically is not that your governing documents will magically change, but rather that the rules written down in your governing documents after October 19th, 2024 may no longer reflect what your true rules are from an ONCA perspective, okay? Because if they're inconsistent with ONCA, they will be deemed to be replaced, for the most part, with ONCA compliant rules. That's not the end of the world, but it is a confusing situation. So to avoid that confusing situation, you may want to complete the process of ONCA transition before October 19th, 2024. Is it possible that your directors and officers' insurance might be affected if you aren't ONCA compliant? I can't imagine how, although always, check the insurance policy itself to see what the conditions are. Being not ONCA compliant doesn't mean you've broken a law. It just means that your governing documents are deemed to reflect rules that are different from what's written down. So it's not necessarily that you've done anything illegal. It's just that your governing documents are a bit confusing. But again, I can't comment without seeing the insurance policy in front of me. I will note, though it's outside the scope of today's session, there are slight differences in the rules for indemnification of directors and officers under ONCA than under the previous act. So it's not that being ONCA non-compliant may affect your D&O insurance, but the rules of indemnification have slightly changed. So that's something to be aware of. So those are 4 reasons to care about ONCA. What are 2 reasons you don't need to lose sleep over ONCA? And as I like to say, there are many better reasons to lose sleep these days. So number 1, there are no ONCA police. It's nobody's job in the government to knock on your door and ask you, have you complied with your bylaws? So you may say, well, there are no ONCA police. Why should I care at all? Well, a couple of reasons. Number 1, it is an opportunity to make your organization better through a renewed governance framework that you've really thought about, and that's relevant to how you actually make decisions. And then secondly, as I mentioned, your funders may care. So even though there are no ONCA police, there are other people who may care. And then finally, under ONCA, your directors, your officers, your members, in some cases, your creditors have rights to take your organization to court if they believe you are not compliant with ONCA. Now, this happens very rarely, so I don't want to, exaggerate the risk of this happening. You know better based on how litigious the people involved in your particular nonprofit are, how likely it is for the organization to be taken to court. But just be aware that your directors, your officers, your members do have these rights. So being compliant protects you against any future legal action in this area. And then finally, another reason you don't need to be worried about the ONCA is that it's not a major overhaul. Yes, there are differences, but by and large, these are comparatively minor differences. If you are familiar with the previous act, Ontario's Corporations Act, by and large, you will be familiar with ONCA. Okay, so with that, I'm going to pause for questions before we jump into what's new in the ONCA. All right. Not seeing any questions. So we are going to talk about...
Actually, I have a question.
Yes, go ahead.
A few, in fact. You sort of alluded to insurance earlier, and one of the offers that's on the table in terms of insurance for our corporation is that there be indemnity insurance for the board and for directors. But I note that there's some provisions in ONCA that more or less say, well, in other words, say that if directors are acting in good faith, that they are not likely to be deemed liable. So question is, should we bother with the additional $700 that particular provision of our insurance would cost?
Right. So yeah. So what's the value of directors and officers insurance? So there are 2 things to note here. There's whether someone's going to be individually liable, and then there's all the costs associated with being sued, right? And proving that in fact you're not ultimately liable. Now, generally speaking, insurance covers those costs associated with being sued. Now, someone may sue you, and you may need to prove, in fact, that you are not liable. And in the meantime, you have to, you have all those costs. The value of getting insurance is that those costs are covered in the meantime. Even if you're proven innocent at the end of the day, it's rare that a court will force one party to pay the complete costs of the other party. They may be forced to pay a part of the costs, which may be something like half the cost, or if it's particularly egregious, maybe up to 80% of the costs. It's unlikely that it's going to be 100% of the costs. So even if somebody turns out not to be liable, then insurance is still valuable in terms of covering any legal costs that arise. Now, Whether it makes financial sense for any given organization depends on its particular risks and how much that insurance costs and so on. So I'm not saying, every organization should have insurance. It depends on your specific calculation. But it's the mere fact that directors are not liable for many things if they're acting in good faith and with a view to the best interest of the organization, that alone doesn't mean the organization isn't going to have costs.
Okay, so I get that, potential costs. I also have another question about review engagements. I don't know if this is the appropriate time to raise that question.
We are going to come to review engagement, so hold on to your question and see if it isn't answered.
Thank you.
Great. Okay, and as far as questions goes, feel free to put them in the chat, or you can also raise your hand when we come to question periods. Okay, so we're going to talk about three things that are new in the ONCA. The first thing is this concept of a public benefit corporation. So it used to be under Ontario Corporations Act that pretty much all nonprofits face the same set of rules. Charities face slightly different rules. Under ONCA, by default, all nonprofits face the same set of rules, but some nonprofits face additional rules. These nonprofits are called public benefit corporations. So this raises two questions. How does an organization come to be considered a public benefit corporation, and what are these additional rules? An organization is a public benefit corporation in either of two cases. Number one, if it's a charity, it's automatically a public benefit corporation. So that's pretty clear. Number two, if it's not a charity, then it may still be a public benefit corporation if last year it received more than $10,000 in either grants or financial assistance from government, and that includes federal, provincial, municipal government, or an agency of government, and or gifts or donations from sources other than members, directors, officers, or employees. And this includes gifts or donations from foundations that are not connected to your organization, or from individuals. So it could be either organizations or individuals. Now, in the second case, the status of public benefit corporation is a year-by-year status. So if last year you received more than $10,000 from these sources, this year you're a public benefit corporation, and you ask the same question next year and the year after that, and so on and so forth. If an organization falls under either of these two categories, either they're a charity or they received this kind of funding last year, then certain additional rules apply. The three main additional rules are as follows. Number one, they are restricted in what property they can distribute upon dissolution. So what do I mean? Sorry, not what property, but to who they can distribute their property upon dissolution. So what do I mean by dissolution? When an organization ceases to exist as a legal entity, okay? Basically, it goes kaput, it dies, right? This is referred to as dissolving. So if you ever dissolve your corporation, the first thing you need to do is pay off any debts you have. Once you've paid off any of those debts, if you have any remaining property, and this includes equipment, real estate, money, intellectual property. Property is a very broad term here. If you have any remaining property, the question is, who gets that remaining property? You may already have a line in your bylaws or your articles that says who gets the remaining property. This is known as a dissolution clause. Now, for a regular nonprofit, you could basically say whoever you want for who gets the property. You could say your members, you could say your community, you could name another nonprofit, you could name another type of nonprofit. You've got lots and lots of flexibility. But for a public benefit corporation, you can only give your property, if you dissolve, to a government, either federal, provincial, or municipal government, or an agency of government, or if you're a charity, to a registered charity with a similar purpose, or if you're not a charity, to other public benefit corporations with similar purposes. Now, I mentioned that public benefit corporation status is a year-by-year status if the reason you're a public benefit corporation is the funding you received last year. There's actually an exception to this, and it has to do with the rules for distributing property if you dissolve. If you were ever a public benefit corporation in the last 3 years before dissolving, then you have to follow this rule, okay? So the status of public benefit corporation lasts a bit longer if you dissolve. The second rule that is different for public benefit corporations is that for a regular nonprofit, in theory, all your directors could be employees of the organization. This is where I remind you that what's legal is not necessarily what the best practice is. It's not necessarily a good idea, but technically it's allowed. Employees are allowed to be directors of a regular nonprofit, unless you prohibit it in your bylaws or your articles. For a public benefit corporation, however, the rules are different. Only up to 1/3 of your directors can be employees. For a charity, there's also charity law to think of, and the rules are even stricter. For a charity, you can only have employees as directors if you can comply with the guide published by the public guardian and trustee called Payments to Directors and Connected Persons. Okay, and I'm typing this in the chat. The situations in which a charity is allowed to have an employee as a director are highly, highly limited. And there's a special procedure you need to follow, even if you meet those qualifications. Okay. So I see there's a question in the chat. Last year or at any point in the previous year, in other words, if in 1 year we received less than $10,000, are we no longer a public benefit corporation? So yes, if last year you received less than $10,000 from the sources I mentioned, in that subsequent year, that organization ceases to be a public benefit corporation. Now, if an organization is going to go between having public benefit corporation status and not very frequently, you may want to make a choice about whether you're going to comply with public benefit corporation rules all the time anyway, just to keep things simple, or you may want to seek legal advice. But yeah, it's a year-to-year determination, except in the case of the dissolution rules, which apply for 3 years. Okay, the final way that we're looking at in which public benefit corporations are different is when it comes to financial review. So the default under ONCA is that every nonprofit has to get an audit each and every year. But some nonprofits have the ability to pass what's called an extraordinary resolution and waive the audit, and they may be required to get a review engagement instead of an audit, or they may be able to waive all external financial review and just prepare the financial statements internally and provide those to the members. So I'm going to explain what's an extraordinary resolution, what's a review engagement, and who has this ability to pass an extraordinary resolution and waive an audit and get a review engagement or not have to get anything external at all. So an extraordinary resolution is a motion typically passed at a members' meeting that enjoys 80% support of the votes cast at the meeting. It doesn't need to be 80% of all your members or even all your voting members. It's 80% of the votes cast at the meeting. You can also pass an extraordinary resolution by outside of a members' meeting by having a unanimous written resolution. So I should clarify, an extraordinary resolution is something passed by the voting members. Okay, so that's an extraordinary resolution. What's a review engagement? I'll explain a review engagement by contrast to an audit. So with an audit, a chartered professional accountant comes in, looks at your source documents, like your receipt and your invoices, looks at your financial policies, like your signing authorities, looks at your financial statements, like your balance sheet and your cash flow, and then based on all of that, concludes whether or not they can provide reasonable assurance that your financial statements are a reliable reflection of your financial position. Contrast that with a review engagement. It's still a chartered professional accountant who comes in, looks at your source documents, looks at your financial policies, looks at your financial statements, but at the end of the day, they're only saying whether or not your financial statements are a plausible reflection of your financial position. Okay, so plausible is not the same standard as a reliable reflection. As a result, review engagements are faster, cheaper, less onerous because it's not the same level of assurance. Okay, it may be appropriate for some organizations, it may not. Every organization needs to make its own determination. Who has this ability to pass an extraordinary resolution and waive an audit and maybe needs to get a review engagement instead? Well, for organizations with annual revenue under $100,000, and annual here means fiscal year, and revenue here is a very broad term. It includes sponsorships, donations, fees for service, basically all the money you're taking in. If your annual revenue is under 100,000, by default, you have to get an audit, but you can pass an extraordinary resolution and waive the audit, and then you don't have to get any external financial review. It's enough just to prepare financial statements and present those to the members. If you have annual revenue between 100,000 and 500,000, it starts to matter whether or not you're a public benefit corporation. If you're a public benefit corporation, you can pass an extraordinary resolution and waive the audit, but you have to at least get a review engagement. If you're not a public benefit corporation, by default, you have to get an audit, but you can waive the audit and you don't even have to get a review engagement. If you are an organization with annual revenue above $500,000, if you're a public benefit corporation, you must get an audit each and every year. If you're not a public benefit corporation, you can pass an extraordinary resolution and waive the audit, but you have to at least get a review engagement. Doesn't the funder have the final say if you have to get an audit or not? So legally speaking, no. You don't have to listen to your funder. They may make it a requirement of the funding agreement, in which case you may be contractually obligated to get an audit if that funding agreement is a valid contract. Okay, so that's another area of law. But funders are not legally entitled to an audit as a matter of corporate law. It's only if they have made an audit a requirement of the funding agreement that they have any legal right to an audit. What if the funder is the government? So again, there may be, in fact, if you've got a transfer payment agreement, a standard provision of the transfer payment agreement is an audit section. There, the word audit is being used differently. It's used to mean that the government can come in and look at all your documents and rifle through your things and whatever to assess whether you've complied with the funding agreement. Again, firstly, that's a different meaning of audit than the way I'm using it here. That's not necessarily a financial audit. That right to an audit is a function of that agreement. So you are bound by the agreements that you signed, and so they may have rights, but the government, as a funder, does not automatically have rights unless they've put it in the agreement somehow. Now, I'll just note that there is another sense of the term audit that's used, which is the Canada Revenue Agency comes and does an audit. And they have a right to do that, whether you're a nonprofit, a charity, or some other kind of taxpayer. They can come in and they have wide rights to look at all your things and ensure you've complied with the Income Tax Act. So in that sense, yes, the government would have a right to do that kind of audit. But when it comes to requesting a financial audit, this is not something that a funder automatically has a right to do. Just to clarify, if the corporation is a public benefit corporation by virtue of the fact that it has received greater than $10,000 in grants, does it at least have to have a review engagement even if its revenues are less than $100,000? No, there's no requirement to have a review engagement if the annual revenue is under $100,000 under ONCA. Was this your question about review engagements, Phil, or did you have another question?
Yeah, actually, that was my question, because my reading of ONCA says basically that if you're characterized as a public benefit corporation, you either have to have, sorry, is there somebody else talking?
No, there's some background noise. Tamara, if you could make sure everyone's on mute who's not currently speaking. Thank you.
Yeah, so that was my understanding of the act, that at least a review engagement has to be undertaken. We're in the position where we make less than 100,000 revenues per year. But by virtue of the fact that in some years we do receive greater than 10,000 in government grants or other
Mhm.
grants, municipal including, um, um, I think it's fairly clear that you really have to undertake at least a review engagement. I can see that you can pass a resolution at your annual meeting, for example, with your members to forego having an audit, which is expensive for us. By the way, I've been quoted $5,000 for an audit and
That's quite
$3,000
normal.
for a review engagement. So we're
Mhm.
not saving all that much for a review engagement. At least it's something that is concerning for us because it's a lot of money. Which raises another question in my mind, and that is that it has to be a chartered accountant to do,
Correct.
regardless of whichever approach you take.
Correct.
Um, um, can it be someone who is qualified but willing to do it on a voluntary basis? Or,
Yes.
yeah,
Um, so thank you for that question. If we have time at the end of today's session, I'll give you a brief tour of the ONCA itself. We'll look in the act and I'll show you where this comes from and why it is we say that there's no requirement for organizations under $100,000 to get a review engagement. So thank you for that question, and remind me if I forget at the end of today's session if there's time. So the third and final thing in this area is the Ontario Business Registry. So when the ONCA went online on October 19th, 2021, a new online system also went online called the Ontario Business Registry. It allows you to do many things, including order a corporate profile. This would tell you who the government has on file as your current directors and your current address. It allows you to file a notice of change. It allows you to file an annual return, which you're obligated to do each year, even if your address, directors, and officers have not changed. Under ONCA, you are required to indicate that these things have not changed. And then finally, if you are required to file articles of amendment as part of your ONCA transition process, you can now do this directly online through the Ontario Business Registry. Just a note, especially for the registered charities on the call, this is not a replacement for any filing you need to do with the Canada Revenue Agency. So your annual information return as a registered charity called the T3010, you are still required to do that. The Ontario Business Registry does not replace that. There are glitches in the system, so watch out. The system is getting better. Recently, the government made some improvements to the system. It's definitely getting better. So, give it time. I'm going to pause here for questions, and then we will take a brief tour of the Ontario Business Registry. So are there any questions? Feel free to put them in the chat or raise your hand about anything I've said to this point.
sorry, I have another question.
Sure.
Um, a CPA that's hired to undertake either an audit or an engagement review has to be independent. In other words,
Correct.
in other words, we can't hire someone who's a member of our corporation or sits on the board of directors. In other words, they have to be at arm's length from the corporation.
The directors for sure not. Whether a member is disqualified is and I don't actually know the intricacies of the rules of independence for accountants, and this is governed by the rules for accountants. So you would ask the CPA Association. I don't actually know in great detail the rules of independence. I think there's some question as to whether a member of a nonprofit is captured, and it may be a question of fact. Meaning if it's a member who's deeply involved in the organization, that may cause them to be considered not independent. But if it's somebody who's just a member and that's it, that may not be enough to say that they're not independent.
Yeah, no, my reading of Public Accounting Act 2004 says independent, so that's why I raised it.
Yep.
Okay, thanks.
Yep, so not seeing any questions, so I will give you a brief tour of the Ontario Business Registry. And I'll show you how to actually go about finding information about your organization in case you're missing any. So I'm going to scroll past all the sketchy sponsored content that makes it look like it's a government website. And I will go to the ontario.ca/page/Ontario-business-registry. I'm going to begin by scrolling down until I see search for a business or not-for-profit corporation. I will click on that. And then I will enter the legal name of my organization. So not just the name that the organization goes by in the community, but the name that appears on things like contracts and my letters patent and so on. Now, if you have trouble finding your organization, there are advanced search terms. You can narrow it down to just nonprofits. You can narrow it down to currently active organizations and so on, but we're not going to get into that. So I'm going to click search. Oh, and there we are, Community Legal Education Ontario. I'm going to click on Community Legal Education Ontario. And you'll see the information that any member of the public can access. Now, to make filings like your annual return and your notice of change and that kind of thing, you would click on this top right thing. If you want to maintain this corporation, you need to be logged in. And I'll explain at the end of this session how you actually go about logging in. But for now, I just want information on my organization. So I'm going to click on this button, Request Search Products, which is on the top left part of the screen. Now it gives me three options. I can order online from the government, online from an authorized service provider, or by mail. Why I would ever order online from an authorized service provider, I don't know. It's an additional fee and it's the same information. So I'm going to click Order from the Ministry. And it gives me three options. It gives me I can order a profile report. Again, this will tell me who the government has on record as the current directors, the current address. This is really important information to know to determine, are you behind on your government filings? If the government has the wrong address on file, as we're going to see later, you're going to get access to make changes in the Ontario Business Registry, you're going to need to ask the government to send you a key by mail. If they have the wrong address on file, they're not going to send it to the right place, or they're not going to send it at all. So it's important to know that they have the right address on file. And similarly, it's important to know they have the right people as directors, etc. You can also order document copies. Document copies will give you a whole archive package of the corporate records that the government has on file for you. So they'll send you a copy of your letters patent. If you ever made changes to your letters patent, this is called supplementary letters patent, they'll send you copies of that. They'll send you past filings and so on. It's a wonderful walk down memory lane. So if you have any big anniversary coming up, it's a great source for slideshows and that kind of thing. You may see names you haven't seen in years and say, oh, this guy, he's dead. Oh, this guy, I'm glad he's not part of the organization anymore. So it's really a lot of fun, and it's quite affordable. Last I checked, it was $3.50. So that's a steal at half the price. So I would encourage organizations as at least a first step to order a profile report for themselves. Okay, jumping back into the presentation. We are going to continue with what steps do nonprofits need to take to bring their governing documents into compliance with ONCA. So step one, figure out whether ONCA applies to you. As I mentioned earlier, ONCA applies to provincially incorporated nonprofits. This includes nonprofits incorporated under Ontario's Corporations Act. It also includes nonprofits incorporated under special acts, such as the Agricultural and Horticultural Organizations Act. And one thing I'll note, if you are incorporated under a special act, unless the special act says you are carved out from ONCA, ONCA would generally apply. If there's any conflict between ONCA and that special act, ONCA yields, the special act wins. Okay, so you do have to make sure there's a conflict to begin with, but follow the special act above ONCA. Now, ONCA does not apply to you if you are federally incorporated under the Canada Not-for-Profit Corporations Act. It does not apply if you are a co-op under the Cooperative Corporations Act. It does not apply if you're incorporated under the Ontario Business Corporations Act. It doesn't apply if you are unincorporated, or if you're under the Condo Corporations Act. It does not apply to you. Okay, so you've made sure ONCA applies to you. Now you want to figure out, when do we want to take action? So I mentioned there's this 3-year transition period ending on October 19th, 2024. What I'll add now is 2 things. Firstly, during this transition period, what are the rules that apply? Well, ONCA says, as long as your governing documents were valid before ONCA took effect, they continue to be valid until October 19th, 2024, even if they contradict ONCA. So practically speaking, the first place you are looking to figure out what your governing rules are is in your governing documents. Okay, and as long as you can be sure that they were valid before ONCA took effect, you can rely on those rules. Now, the second thing I'm going to add is, at the end of the transition period, I mentioned that ONCA will consider most of your rules to be transitioned over. So that raises a question: what are these rules that won't be automatically transitioned over? So I'll give you the three main areas that won't be transitioned over. In all of these examples, previously, before ONCA, you could put these rules in your bylaws, and now ONCA wants us to move them to our articles. But the special exception is that if we continue to have these rules in our bylaws, as long as we don't make any changes to them, they continue to be valid indefinitely. But if you want to make any changes to them, you're going to have to do so in your articles. To avoid a confusing situation where down the road they keep being in your bylaws, someone sees they're in your bylaws and thinks, oh, all I need to do is change the bylaws to change these rules, which would create a problem, because at that point you would need to change the articles. To avoid that confusing situation, you may want to move these rules over to your articles anyway, but just so you know, ONCA does not, strictly speaking, require you to move the rules I'm about to list from your bylaws to your articles. So what are these special exceptions? Number one, the size of your board. If you have a fixed number of directors set out in your bylaws, so for example, your bylaws say there's 8 seats on the board, or there's 12 seats on the board, etc., that continues to be valid even past October 19th, 2024. But if you ever want to make changes to the size of your board, you would have to do so in your articles. Number two, membership classes and member voting rights. Nonprofits can have more than one kind of member, and they can have different rights to vote. For example, you could have one class that has the right to vote and one class that doesn't have the right to vote, or one class that has 5 votes per member and another class that has 1 vote per member. That's entirely up to you. What ONCA says is that if you have 2 or more classes, that needs to be put in your articles. That information needs to be put in your articles. Similarly, if the voting rights are anything other than 1 member, 1 vote, that information needs to be put in the articles. And then finally, a dissolution clause. Nonprofits are required to comply with the public benefit corporation rules if they're public benefit corporations. So that applies regardless. But ONCA additionally says that even for a regular nonprofit, if you want a dissolution clause to be valid, it needs to be put in the articles. So as long as your dissolution clause is otherwise valid, it won't be invalid just because you have it in your bylaws. It'll remain indefinitely in force as long as it's not otherwise invalid. Okay, but if you ever want to make changes to the size of your board, to your membership classes, to their voting rights, to your dissolution clause, going forward, you're going to have to do so in the articles. So that gives you a sense of your window of time to act. But how long does it actually take to transition to the ONCA? Well, a typical estimate that lawyers who work in this area give is 6 to 12 months. What could cause this transition to take shorter? What could cause it to take longer? I'm going to go through 4 common factors that might cause it to take shorter or longer. So number one, the age of your governing documents. If your organization has been around for a long time, then it's quite likely, and particularly if you haven't looked at your governing documents in a while, that there will be more to change than simply what ONCA requires, okay? That's going to take longer to change, so be prepared for that. Secondly, the capacity in your organization. When was the last time your directors read the bylaws? If it wasn't in a while, then there's going to be a learning curve that you're going to have to dedicate some time to. And that's actually part of the value of the ONCA transition process. It's an opportunity to educate yourselves, but that does add to the time. Similarly, do you have a budget to, for example, work with a lawyer? That in some situations may speed up the process, but it depends on whether you have a budget for that. The capacity also means, do you have staff? If so, are the staff able to manage part of this process, etc. Thirdly, consensus. Sometimes ONCA kicks up the dust of issues that have long been left to settle. Things like who should really be a member, what's the real size of the board, etc. And it may be that there are big factional disputes, different opinions on your board or among your members or between your board and your members and so on. Raising all these issues is a great opportunity to move towards greater consensus in your organization, to deal with these issues, finally put them to rest, and go forward with greater unity and harmony in your organization. But it takes time to work out those differences. So, budget time accordingly. And then finally, ease of holding members' meetings. As we're going to learn in a few slides, membership approval is required for changes that you make to your bylaws and articles, and typically membership approval happens at a members' meeting. If it is hard for you to hold a members' meeting, and so you end up only just holding the one required annual general meeting, then that means there's going to be some delay before the process is completed. But if it's easy for you to hold the meetings, let's say because you have a small number of members or your board members are the same people, you can do that, and it will speed up the process. Now, at this moment, I'm going to take the opportunity to address some common questions about working with lawyers. The first question I'll address is it required to work with a lawyer? And the answer is no. There's no legal requirement that a lawyer needs to sign off on your bylaws or your articles. It may be advantageous to do so, particularly if you have a complex corporate history or if you're part of a network of organizations. So what you do in your governance may affect other organizations, or if you're subject to multiple acts, there may be complexities that a lawyer could help out with, but there's no strict requirement to work with a lawyer. The second thing I'll note about working with a lawyer is that it's never all or nothing. It's never all, because although a lawyer can generate perhaps a legally compliant set of bylaws or articles for you, unless they happen to be very well acquainted with your organization, it's unlikely that those governing documents will necessarily reflect the particular culture, the values, the relationships, and so on of your organization, unless you're willing to take the time and money to pay them to get very acquainted with your organization. It's also never all, because at the end of the day, I mentioned earlier, legal compliance is not just what's in your governing documents, it's how you actually integrate that into practice. So you need to educate yourselves to understand what those rules are, why they are in place in order to comply with them. Now, many lawyers, particularly good lawyers, will take the additional step to educate their clients and so on, but depending on what your budget is, that education may be limited. So you've already taken steps to educate yourselves by attending this workshop, but that education should be an ongoing process, not only for your current board, but future boards and so on. Now, it's never nothing, or it doesn't have to be nothing, because even if you decide to do a lot of the work yourself, you use CLEO's bylaw builder tools and other tools that we have available for free on our website to maybe identify what you need to change or draft some of those changes. You can do that, and you could limit what the role a lawyer plays to, for example, addressing specific questions or commenting on things you've already drafted, and that will reduce their work and will often result in cost savings and time saving. All right, Rachel asks, should dissolution details / info be in both the letters patent and bylaws? A great question, because it highlights a broader question of, is there any reason to have information in both the letters patent and the bylaws? So the short answer is there's no requirement to have something in both. If you have it in one, that's enough. And I should note that the letters patents are more authoritative than the bylaws. So if there's any conflict between them, the letters patent is going to win. If you have rules in both your letters patent and your bylaws, this is typically done because, for example, nonprofits do not regularly read their letters patent, but may regularly read their bylaws. And so you want all the rules to be in the bylaws so that when people read the bylaws, they see them all in one place. This is a fine reason to do something. However, be aware that if somebody doesn't understand that the rule is both in the bylaws and the articles, and then in fact the rule needs to be in the articles, they may in the future make changes to the bylaws, not realizing that those changes aren't valid. Okay, so one way to address this problem, if you do want to have a provision both in the articles and in the bylaws, is to reference in the bylaws that this same rule can be found in the articles. It's in the letters patent, but I don't see it in the bylaws, so I wanted to make sure things are correct. Yeah. So if anything that you can put in the bylaws, you can put in the articles. Putting something in the articles makes it more cemented. It gives it greater legal weight. It's harder to change, and there are penalties in theory that someone could pursue in court if the organization violates its articles. Okay, so once you've figured out when you want to take action, then you may want to get your books and records in order. This is always a good idea. You don't need to wait for ONCA in order to get your books and records in order. So what books and records does ONCA require you to keep? So number one, you need your letters patent. And if you ever made changes to your letters patent in the past, it would be called a supplementary letters patent. So you should have that as well, so you really know what by reading them both together, what your founding rules are. Secondly, your current bylaws, and make sure it's the current version. Thirdly, your minute books. ONCA requires you to keep 4 types of minutes: board meeting minutes, members meeting minutes, board committee meeting minutes, member committee meeting minutes. ONCA requires us, in theory, to keep all of our minutes, okay, going back to the very beginning. Now, you may say, what? We've been around 90 years, 120 years. There's no way we have all our minutes. This is where I remind you, don't worry, there are no ONCA police. Practically speaking, the risk of not having minutes is as follows. For the past 7 years, there's an obligation under the Income Tax Act that we have all the records that might be relevant to the CRA auditing, okay? So it is a problem if we're lacking records in the last 7 years, and may be worthwhile to try to reconstruct those records, because if CRA asks for them and we don't have them, that in itself, even if we haven't done anything nefarious, that in itself could be a violation of the Income Tax Act. Past 7 years, the question is really, do we need records to rely on in case a legal issue is ever brought up? So for example, did our organization engage in some kind of risky activity that year, like buying new land, or we had some kind of program with children? And so if there's any kind of abuse allegation in the future that we dealt with in that year, the board may want to have records showing that it did its due diligence and so on. Not having those records simply means there's less evidence to rely on. If the records don't reflect anything good about the organization, then it may ultimately not even be such a a negative thing from a strictly legal perspective for the organization not to have those records. Though don't go out and destroy records, because that in itself could be an illegal action. So all of that is just to say ONCA requires us to keep our minutes, so we shouldn't be going out and shredding minutes. But if we don't have minutes, from 30 years ago, practically speaking, the risk is likely very low. Every organization needs to do its own risk assessment. Now, ONCA allows us to keep our minutes virtually. We can keep it on the cloud, we can keep it in Google Drive, Dropbox, what have you, as long as the records are accessible from some computer in Ontario by default at our official address, or another address that our board designated through a board resolution. Many records can also be kept outside of Ontario if designated by the board, if it's an address that the board designated. But bottom line, we can keep our minute books virtually. Special resolutions. So earlier we talked about extraordinary resolutions, which are motions that require 80% support. A special resolution is a resolution that requires a 2/3 majority support. Typically, if something is a special resolution, it's because it deals with some important item. So if we have any, it would be important to know what these resolutions say, or it could be at least. Directors and officers register. Register here is a fancy legal word for list. The ONCA requires us to keep a list going back 6 years of all of our current and former directors and officers, including the names, the start date, the end date, their personal address or address for service. So address for service just means the address where they agree to receive official documents from the nonprofit. This could even be the nonprofit's own address if they agree to pick up those documents at the nonprofit, okay? So it doesn't have to be their personal address, but you do have to have an address on file for the directors and the officers. And then if they agree to receive documents electronically, their email address as well. And then for the officers, what type of officer they were, what was their title. Your bylaws and articles may also require you to keep other information in this register. Nonprofits are also required to keep a list of all the members going back 6 years. Again, it's the first name, last name, okay, so their names, their start date, their end date, if they stop being a member in the last 6 years, their address for service or personal address. So again, this doesn't have to be their personal address. You could give an address where they agree to receive documents. It could even be the nonprofit's own address, and an email address if they agree to receive documents electronically. Now, if you have multiple classes of members, you would also include what type of member that member is. And again, your bylaws and articles can specify other information that you would keep in your members register. ONCA requires us to keep director consent forms. What's a director consent form? If someone's been elected as a director, that is not enough for them to start serving as a director, because then you could elect anybody you want as a director without telling them, right? You could elect Keanu Reeves to be on your board and phone Keanu up 4 years later, say, haha, you know, you've been liable this whole time. You can't just do that. You need to get Keanu's autograph first, okay? On a document that basically says, I so-and-so agree to be a director of X organization, so the name of the organization, as of X date, so the start date for their directorship, the address of the person, so we know who we're talking about, and their signature, okay? You can have a more complex form if you want. You know, I get asked, do nomination forms count? Do codes of conduct count? All of these could potentially count, as long as it's clear in writing that director agreed to be a director of the organization. Now, you only need to get this once for as long as they consecutively serve as a director. So if a person just keeps serving one term after another and they end up serving 20 years, it's fine. You could only have one consent form. But if somebody serves 1 year, takes a break, then comes back the next year and serves another year, you would need a second consent form that second time. And then your annual revenue. It's important to know your annual revenue to figure out what financial review standards do we need to do. Are we a public benefit corporation, etc. Make sure the government has the right address on file. I mentioned this earlier, because you're going to end up requesting what's called a company key in order to access the Ontario Business Registry, and they are going to send it to your address. So one thing that's new under ONCA is the government no longer accepts PO boxes as an official address. You need to give a physical address. Now, we know that this disproportionately affects rural, remote organizations. It disproportionately affects smaller organizations. We've brought this to the attention of the government a number of times. Recently, there was a red tape reduction bill. Unfortunately, it did not include any changes to this policy in that bill. So if this is a current concern for you, feel free to raise it with the Ministry of Public and Business Service Delivery. In the meantime, what can you do if you don't have a physical address? You can, many municipalities have an agreement where community centers can be used as mailboxes for local nonprofits. So ask your local community centers. B, if you're working with a lawyer or an accountant, often their offices, they're willing to use their offices as the official address of the nonprofit. C, there are some, in some areas, there are shared workspaces. For example, in Toronto, we have the Center for Social Innovation. So you may look to see if around you there's any kind of shared workspaces. If anybody has any additional suggestions about, where to find a physical address or mailbox, then I encourage you to share that with others in the chat. Okay, so once you've got your books and records together, now we can start looking at our governing documents and see what we might need to change or want to change. So here are just 5 examples of things we might need to change or want to change in our bylaws. The ministry, so the government office that asks for your correct address is Service Ontario. That's governed by the Ministry of Public and Business Service Delivery. And you can find what address they have on file by searching yourself on the Ontario Business Registry. So here are 5 examples of what you might need to change or want to change in your bylaws. So number 1, previously under Ontario Corporations Act, there was a requirement to have a president and a chair. That's no longer a requirement under ONCA. Now you're required to, a president or a secretary. That was previously required. Now under ONCA, you are required to have a chair. Okay. The chair needs to be a director as well. So remember, I mentioned directors and officers are different, but they can be the same people. So in the special case of a chair, the chair is an officer position that's required to be filled by a director. Your other officers are not required to be directors unless you say so. In fact, you're not required to have any other officer positions, so it's entirely up to you whether you want to have any officer positions. But you are required to have a chair, and the title needs to be chair, not chairman, not co-chair, not chairwoman. It needs to be chair. The online system will reject anything else. Secondly, corporations can be members of a nonprofit. If you want to allow a corporation to be a member of your organization, you need to spell that out explicitly or use terminology that includes corporations, such as person. For example, a person may be a member of the nonprofit if, etc. Thirdly, if you have multiple membership classes, remember I mentioned earlier that now needs to go in the articles, but ONCA wants you to spell out in your bylaws how someone could join each class of membership, how membership in each class ends, and how to withdraw or transfer between classes. So in general, ONCA wants us to be more explicit in our governing documents. Number 4, members have all kinds of new rights under ONCA. One of these rights is that members who control 10% of the vote in your organization can get together and demand in writing that a members meeting, demand in writing to the board that the board call a members meeting. And the board would have to call a members meeting unless certain exceptional circumstances apply. And then finally, number 5, proxy voting. By default under ONCA, proxy voting is not allowed. So if you want your members to have the power to vote by proxy, you have to say so explicitly in your bylaws or your articles. So just to clarify, what is proxy voting? Proxy voting is where your member cannot or does not want to attend a members meeting, so they appoint somebody else to vote on their behalf. Proxy voting is never allowed for board meetings, period. Directors are not allowed to delegate to somebody else their vote. Okay, so this is one example of how even if directors and members are the same people, which is an allowable structure, even so, there are different rules that apply to board meetings and members meetings. But in brief, proxy voting by default is not allowed. If you want to allow it, you have to say so in your bylaws or your articles. Now, what might you want to change in your articles? Here are 4 examples of things you might need to or want to change. So number 1, your purposes. Nothing in ONCA requires you to change your purposes as an organization, but especially if this is the first time you are reading your letters patent in a long time, you may pull out your letters patent, read your purposes and say, what? We don't do that. Or, wow, that language is pretty outdated. So you may want to update your purposes. If you are a registered charity, be careful because changing your purposes may compromise your charitable status. Okay, so if you're planning on changing your purposes, this is an area where consulting with a charity lawyer may be highly advisable. Number 2, the number of directors. So I mentioned earlier that ONCA requires us to specify the number of seats on the board in our articles, not just our bylaws anymore. What I'll add here is that under ONCA, the board size needs to be at least 3. And in addition to specifying a fixed number, so you could specify 9 or 12 or 15 or whatever you like, ONCA allows us to set out a range. Previously, this was not allowed. If you have a range of seats on the board in your bylaws, that is not valid under either Ontario Corporations Act or ONCA. If you're subject to a special act, there may be different rules, but for the regular nonprofit, it was not allowed in the bylaws. So if you want to have a range, you would do that in your articles. The range could be 6 to 14, 12 to 24, 19 to 56. You could have whatever range you want. Membership classes and voting rights. If you have more than one class, or if your voting rights are different from one member, one vote, then you would need to put that in your articles. If you want to restrict your nonprofit's powers, this would have to be done in the articles. This is not the same as restricting the board's powers. When you restrict the board's powers, effectively what that does is requires the board to seek approval from the members. Restricting the nonprofit's powers as a whole in your articles means that not even the members could approve a certain type of action unless they were willing to change the articles. So why might a nonprofit choose to do this? Well, let's say, for example, you are a heritage building or a land trust. You may want to say in your articles, we're never going to sell the building or we're never going to sell this particular land, right? Or if you're a religious organization, maybe there are certain, religious tenets that you want to build into the articles that the organization never do X, Y, Z. If you want to restrict your nonprofit's powers, that needs to be in the articles in order to be effective. So that's what you might want to change. What's the actual process of going about approving these changes? So just a disclaimer, your governing documents may set out your own approval process, in which case follow that. However, there are certain aspects of the approval process you cannot change. One of the aspects is the members have final say, okay? And any changes to the articles needs to be filed with the Government of Ontario. What I'm about to describe is a default process if your governing documents do not provide an alternative. So firstly, somebody proposes changes to the board. ONCA doesn't say who it has to be. It could be a committee of your board, it could be your staff, it could be a joint committee of board and staff, it could be your members, it could be a lawyer you hired. It doesn't matter. Somebody needs to propose changes to the board. The board then votes. When the board votes on changes to bylaws, those changes are effective immediately unless the board resolution says otherwise. Okay, the board resolution can delay when the changes take effect. They can make it conditional, for example, on the members approving the changes or something else. But if you say nothing, the board's approval of bylaws mean those changes are effective immediately. But the board changes, the changes to the bylaws made by the board are only effective temporarily until the next time the members have a chance to approve the changes. Okay, so it's only valid up until the next members meeting. The board vote on bylaws is a simple majority vote or subject to whatever other rules of voting you might have in your governing documents. When the board votes on changes to articles, it's different. That approval is only an approval to propose changes to the members. The board does not have the unilateral power to change the articles. Again, it's a typical vote subject to the ordinary voting procedures. within your governing documents. Excuse me. Next, your members need to approve the changes. So this could happen at a special members meeting called just for this purpose, or at an annual members meeting, or it can happen through a unanimous written resolution. If you can get all the members who are entitled to vote to sign on to a resolution approving the changes, then you can also approve the changes that way without having to have a members meeting. What do you need in order to conduct a valid official members meeting? Well, firstly, you need to send out proper notice of the members meeting. The notice needs to be sent sufficiently in advance. Under ONCA, that means between 10 and 50 days. Again, your governing documents may specify something, may say a range of days or a specific number of days in advance, in which case, follow that, but it needs to be at least 10 days in advance. I'll note 10 days is not 10 business days. It's what's called 10 clear days, meaning 10 days, not including the day you send out the notice, not including the day of the meeting. Okay, same thing for 50 days. The notice needs to include sufficient detail to allow your members, your voting members, to form a reasoned opinion about what they're being asked to vote on. Whether they do form a reasoned opinion is, of course, up to them. You know your members better than I do, but you need to at least provide them with sufficient detail. What does sufficient detail mean? Does it mean you need to provide the old and the new bylaws? Does it mean you need to provide a track changes document or a summary of all the changes? ONCA doesn't say. But one thing I'll flag for you, just a practical consideration, okay? This isn't a legal standard. This is more a practical consideration. Think about your voting member who is most likely to raise a concern at the members' meeting that they didn't get enough detail in advance. How much detail do they want? Okay, if you don't meet that standard, then what may happen is you put all this work into all these changes, you go to the members' meeting, and then the meeting is completely derailed by a debate over whether enough notice was sent. And then you miss your deadline and nobody's happy. Okay, nobody wants that, not even that member. Who wants all that detail. So again, that's not a legal standard, but practically speaking, it may be very helpful to try to meet that standard. So there's a question about quorum, and that's I'll get to quorum in just a second. So hold on to your question. The next requirement of notice is that it be sent individually. It's not enough to just post something on a bulletin board or to post it on Instagram in a kind of general way. By default, you can send notices electronically, you can send them by mail, you can send them in person, but it needs to be sent to people individually at the last known address that you have for them. Okay, address or email address or what have you. Okay, the next thing you need for a valid meeting is quorum. So Chris asks, for quorum of members or extraordinary resolutions, is that all the members or all the members attending the meeting? We have a number of members that rarely attend. So a percentage of a vote is a percentage of the votes cast at the meeting. Okay, now in order to have the meeting where you can cast votes, you need at least a quorum of voting members. Now, ONCA sets out a default quorum, and what I want to emphasize is that this is just a default, meaning you can change it in your bylaws or your articles. The default quorum is 50% plus one of all your voting members. So if that is hard for you to achieve, it may mean you need to make your meetings more interesting. Okay, maybe offer dinner, maybe offer a show, right? So that might be one way to get more people involved. Maybe people don't understand what the purpose of meetings are, or they see it as just an administrative exercise and they don't see it as an opportunity for communal democracy or anything like that. So there are many things you can do, practically speaking, to make it easier for people to come, to make it easier to achieve a higher quorum. But if you really can't achieve a higher quorum, then you have the option of setting a lower quorum. You could set a lower percentage, you could set a lower number, you could come up with some formula for how to determine quorum. You have lots of flexibility for what your quorum is. You just need to set it out in your bylaws or your articles. Once you have the official meeting, then you need to take a vote. When it comes to changing bylaws, the vote is 50% plus one of the votes cast at the members' meeting. to change the bylaws unless your governing documents say something else. Now, when I say 50% plus one, what I mean is a simple majority. Okay, I'm using this as a synonym for a simple majority. To change the articles, it's different. To change articles, you need a 2/3 majority. What I called earlier a special resolution. Okay. Now, when your members have approved changes to your bylaws, you're done from that perspective. You've completed the transition in your bylaws. If you're a registered charity, you're required to then file those bylaws with the Canada Revenue Agency, but the CRA does not approve those changes. They just want to have those changes on file. In contrast, the articles do need to be filed with the Government of Ontario. So how do you go about filing your articles with the Government of Ontario? So the first thing I'll note is that when you are making changes to your articles, what you are filing are called articles of amendment. Okay, so a new document that's explaining all the ways your articles are going to change. So this is the document you're looking for online, articles of amendment. There are 3 ways to file articles of amendment with the Government of Ontario. Number 1, through the Ontario Business Registry. Number 2, by mail. And number 3, through a third party. Now, to file through the Ontario Business Registry, you're going to need 3 things in order to log in. Number 1, a company key. Number 2, a One Key. And number 3, Service Ontario account. You may already have a One Key and Service Ontario account, particularly if you have any funding from the Government of Ontario. You can use those same login credentials for this purpose. Okay. If you don't have them, you can create them online. It's a username and password type situation. The company key is a bit more complicated. The company key, you need to go on the Ontario Business Registry website, scroll down, and actually order the company key. The company key will then be sent to the address that the Government of Ontario has on file. It'll ask you to enter the address. If you enter the address and it says error, error, it might mean that the address you're entering is not the address that the government has on file. Okay, so that's how you order a company key. And I'll just note about ordering a company key that it can take 1 to 3 weeks to get it. And make sure you don't have multiple people in your organization ordering a company key, because if you order it multiple times, the government is going to send you multiple company keys, and every subsequent company key is going to cancel the previous company key. So you'll get one company key in the mail, and it's not going to work, and you're going to wonder why. And then another company key is going to show up a few days later, and it's going to work, and that's why the first one didn't work. Okay, so be sure not to order more than once. So the Ontario Business Registry is just one method. Method number 2 is by mail. So the way you file by mail is by going to the Ontario Forms Repository website online, downloading the form, filling it in, and mailing it in. You are still going to need a company key if you want to mail in forms. There's a box in the printed forms where you're expected to put in your company key. So what if you don't want a company key or you don't have one? How can you actually make changes? For example, if the government has the wrong address, how can you actually file the changes to the address if you don't have a company key in the first place? There's only one way, unfortunately, and that's working through a third party. So on the Ontario Business Registry website, there are 2 third parties listed, ESC Corporate Services and Dye & Durham Corporate Services. They charge an additional fee of, I think, $150 to $250. But they only require login information. So if you don't have an up-to-date address, the first stop is to go to these third parties, update the address through them, and then you would have the correct address. You could order a company key and then continue to do things yourself. I'm going to pause for questions before I finish with a brief tour of CLEO's website to show you all the resources that are available to you. Are there any questions about anything I've said or not said that people would like to discuss?
I have a question, Ben.
Yes.
You might have alluded to this, but I had to step away from the computer.
Mm-hmm.
I'm just looking at our profile report from the business registry,
Mm-hmm.
and it's got a list of directors that are no longer here. Do
Yep.
they just keep that there?
No, so the obligation of an organization is to file what are called notices of change or annual reports. So I'm going to go to the nonprofit law website. I'll do it actually on another tab. nonprofitlaw.cleo.on.ca. So this is our website. And under run a nonprofit, you will see government filings. And it will walk you through what you need to file. Basically, the notice of change is you submitting a document to the government saying, our directors have changed, this is who's currently a director. If you're many years out of date, then you may need to call Service Ontario and have a conversation with them about, you know, why you shouldn't have to file for every single year that you've missed. And typically, what I've heard is Service Ontario is quite understanding, and as long as you have the current directors, the accurate information, and online, then that should be fine going forward. But it's really a one-on-one basis that they make this determination.
Okay, thank you.
My pleasure. Any other questions? Okay, not seeing any, so I will jump back to the website and I'll give you a brief tour of the resources that are available to you on this website. And then, as I promised, I'll give you a brief tour of the Ontario Not-for-Profit Corporations Act so you can actually understand how to look at it yourselves, and I'll look specifically at this idea of who needs to get a review engagement at what income thresholds and so on, as an example of how to read the Act. So this is our website, and you'll find information if you know people who are starting a nonprofit. There's information on how to start a nonprofit. Most of the information about how to, the rules under ONCA can be found under running a nonprofit. So there are different pages organized by topic. But for the information covered today about the actual process of coming up to date with ONCA, that you can find in the section Transition to ONCA. And most of our tools can be found under Step 5, Update Bylaws. So we have a bylaw builder. So this asks you a series of questions, and based on your answers to these questions, spits out a set of bylaws that are meant to be ONCA compliant at the end of the day. If you are creating bylaws from scratch, this is a great tool. Even if you're not creating bylaws from scratch, this can still be a great tool as it can generate sections that you can then use and maybe put into your updated current bylaws. There's a guide that goes along with the bylaw builder that highlights different trade-offs, some of the practical considerations when making choices about how to update your bylaws. We have a sample set of bylaws with different options. So this is a great place to find some sample text. It's based on the government sample bylaws or default bylaws. And then we have a guide to adjusting your bylaws. So we actually have two guides in this section. One guide that's highlighted basically gives you a side-by-side comparison of typical provisions under Ontario Corporations Act bylaws and how they change under ONCA. This is really a high-level overview. And then if you scroll down, there's a further workbook that gives you a very detailed breakdown of what you might need to change or want to change. So you can use this workbook to do a pretty thorough analysis of your governing documents to identify what you need or want to change. The session that we're doing on December 6th is based on this workbook. We're actually going to be working through this workbook together in detail. Other resources that are available to you on this website include a glossary of terms if you're new to this area and want to learn more, different membership structures and the pros and cons of each. So one of the big questions that may face you as you change your governance structure may be who should be a member, right? Remember, I mentioned that's a very important question. So this page goes through the pros and cons of different common structures. If you do believe you need legal advice, we have a directory of lawyers that work in nonprofit law. We do not vet or recommend any particular lawyer. And as I mentioned, we do not provide legal advice or legal services ourselves, but we did compile this list of people who either they've published on nonprofit law issues, or they've signaled that they serve nonprofits on their website. In some way, we confirm that nonprofits form a part of their practice. And, you know, it's not everywhere in the province, but it does cover a large part of the province. All right. So that's a general overview of the free resources available to you on our website. Are there any questions at this point before I jump into a brief tour of the legislation itself? Okay. Not hearing any. So we're going to go back here and we are going to go to the Not-for-Profit Corporations Act. So the first thing is, if you Google Ontario Not-for-Profit Corporations Act, this is one of the first pages that will come up. But if you don't want to Google it, you can go to ontario.ca/laws, and you can search Not-for-Profit Corporations Act here, and it should come up. The first thing I want to note is that you shouldn't be confused by the name Not-for-Profit Corporations Act 2010. This number, this date, refers to when the Not-for-Profit Corporations Act was passed. So it was passed in 2010. Now, why it only took effect in 2021 is a long and convoluted story, perhaps for another time, though if someone's interested, I'm happy to address it in brief. But the bottom line is, it says 2010, but don't worry, it's still the current version of the Act. You can make sure it's the current version of the Act by looking at the Versions tab, and you'll see it says current here. So we scroll down and we find a table of contents. The table of contents is your best friend whenever it comes to reading any legislation. So you want to think, what is our question, and could we find it somewhere in the table of contents? So our question was about review engagement. Do public benefit corporations need to get a review engagement if their annual revenue is under 100,000? So I'm going to look through all the section heads: capacity and powers, directors and officers, doesn't sound like it'll be there. Members, doesn't sound like it'll be there. Proxies, doesn't sound like it would be there. Auditors, maybe. So I'm going to start looking closer. Qualifications for auditors, filling vacancies, auditors' right to attend, annual financial review. So that sounds like it may be promising. So I'm going to go there, see if that's relevant. It says, an auditor of a corporation or a person appointed to conduct a financial review engagement shall examine the financial statements. So it doesn't tell us who needs to get it. It just says the auditor needs to do it. So that's not very helpful. So I'm going to go back and I'm going to keep looking. I don't see anything. So financial disclosure, anything in there? Approval of financial statements, presentation of financial statements? No. Corporate finance, anything in there? Borrowing powers, members' annual contribution, ownership of property, investment, distribution of property, surrendered membership? No. Records, fundamental changes? No. Liquidation, dissolution? No. Investigation, remedies and offenses, doesn't sound relevant. So maybe it's going to be in this section called general section. Thank you. Phil's pointed to 76. So let's go and check out 76 to see if that's the relevant section. Dispensing with audits. Thank you. I overlooked 76. So public benefit corporation. So members of a public benefit corporation may pass an extraordinary resolution to have a review engagement instead of an audit in respect of the corporation's financial year if the corporation had annual review in that financial year of more than 100,000 or such other prescribed amount and less than 500,000. Okay, so if you dispense with an audit, you have to get a review engagement if you're more than 100,000 and less than 500,000, or to not appoint an auditor and not have an audit or a review engagement in respect of a corporation's financial year if the annual revenue was less than 100,000. So here we go. We found an answer, 76 sub 1 sub B. If you're under 100,000, you don't need to get a review engagement if you pass a resolution waiving the audit and the review engagement. Great. So So again, the way we did that was by going to the table of contents. I actually missed it, so read the table of contents carefully. And looking at the relevant sections. So thank you very much for joining us today. I'll see one last time. Are there any questions about anything we've discussed before we break for today?
Will there be some kind of email going out about the December 6th session, you said?
Yes, actually, thank you, Deb. I was just wanted to take a moment to thank Benjamin for, I can't believe you can talk for 2 hours and be engaged. This is amazing. We are having a full day with Benjamin on December the 6th at the Trent Port Marina in Trenton. I will send a recap of this 2-hour session that we've just had. And in that will be a link to the Eventbrite to register. We are a nonprofit organization, and so our services are free to you. So kindly, if you want to join, lunch is provided and you can spend all day, bring your patents, bring your articles, and the workbook will be part of your afternoon engagement. If Benjamin has anything more to say about our December 6th journey, we're not gonna fly him in. I think we're gonna drive him into Belleville, Trenton area, and hopefully people will be able to join us. I will be sending the recap email with his slide presentation. Again, thank you for your generosity, Benjamin, and the YouTube link of all of our recording here. So thank you again. Benjamin, do you have anything I can't believe, like, the thing that I really found interesting was reviewing the nonprofit article, the way you went very clearly on purpose, number of directors, membership classes, and voting rights. Like, these are the things we have to look at, that maybe you're just starting, or maybe, like you said, it's been a million years, right? Restrictions on nonprofits' power. Wow. Let's get our ducks in order, right? Due diligence.
Yep.
So just to clarify, that December 6th is only available in person?
Yes.
That's correct. Yeah. I will note that it's not the only time I'll ever be doing that session. So if you are signed up to the Ontario Nonprofit newsletter, you may hear about future opportunities to do that session online. I will say that doing it in person is like head and shoulders better than doing it online. You get all the side conversation with the other people you meet there. You learn a lot more about what other people are doing. I'll tell you right now, it's a working session, and the way it works is I give a few minutes on a topic, then people actually look in their governing documents to answer questions in the workbook, and then we come back and discuss. If you're shy about asking questions in crowds, I'm always walking around during that time where people are reviewing their workbook, so there's a bit more opportunity for some one-on-one discussion and so on. So there's real value to doing it in person. Vince, go ahead.
Thanks, Benjamin. And obviously you and we've had conversations going on for a few years here now. And one of the things that I found most interesting is, from my world, is I always thought annual meetings were public meetings and it's more for members. So that's one thing with us, with the Ontario Association or the Ag and Hort Act, that I had to get my head around. We had a very successful board meeting this past week. We narrowed down our documents from 47 pages down, got them down to 30 pages again, which is up from 15 from before. But we're getting it narrowed down, so now we can get someone to legally review those documents. But I just wanted to share with the group that these are really valuable information sessions here. And I know I've heard this one several times. Benjamin and I have had considerable conversations and still lots of questions. So just appreciate everything are doing. So just wondering how you're fitting this all in with you going on your leave here shortly. So
Yeah, I'll be going on parental leave soon. Any day now. I'm expecting a baby. So thank you very much for those kind words, and it's my great pleasure. It's not fitting it all in. This is the main work. So this is what I'm here for.
So this session here, Benjamin, is in my backyard. I'm in Quinte West, so that's kind of why I'm joining it and was part of it. And I know some of the stuff we'll be doing in December, probably you won't be able to assist us a lot with where we are, but it'll be interesting to hear where everyone else is, and maybe we'll be able to gather some additional insight. So.
So there are a few questions in the chat as well, so I'll address
Perfect.
those now. So what was number 4 of ordering the company key? So when you order the company key, expect it to take 1 to 3 weeks. It's going to be mailed to you. Don't order it more than once. Okay, if you order it more than once, the subsequent orders are going to cancel your first orders, and that is going to be super frustrating.
Right.
I think there was another. No, it's all about the December 6th sessions. Okay, yes.
I have to thank Rachel, my colleague down the hallway there. Rachel, you're adorable. She's answering. She's so pro, like Small Business Center and Trenval. She's giving information about the event that we're having December 6th. And like I said, I'll send that in the recap workshop too. Benjamin, you're like a compass. Every nonprofit should have you in their back pocket as a compass to how to run and govern ourselves accordingly. Thank you so much for your time today. Thank you everybody for showing up. You have Ben's direct contact also in your recap, and see you December 6th. Thank you very much.
Bye.
Thank you.